Good morning, Ms. Madavha.
Good morning, DCJ.
How are you?
I'm good, and how are you?
I'm fine, thank you. How do you feel? You look a bit nervous.
No,
If you are, you have no reason to be. You're in good company.
No, I'm settled.
Good, good. You are a holder of an LLB degree which you obtained from the University of Venda in 2001.
Yes.
And just looking at the trail of your CV, you went directly to do your articles
Yes.
with Legal Aid South Africa.
That is so, DCJ.
And after obtaining your articles of clerkship, you joined the National Prosecuting Authority.
Yes, that is from 2004 until
2006 as a regional court prosecutor.
Yes, I've actually prosecuted in both districts and regional courts.
All right. And what happened between 2006 and 2013? Your CV reflects that you're a relief prosecutor, or what does that mean?
A relief prosecutor simply means you are granted relief duties to assist in different courts of the said cluster. So I was actually a relief prosecutor in the Thohoyandou cluster in both district and regional courts.
I see. And that was for about 7 years?
Yes.
All right. And then you decided to take the leap and join the bar?
Yes, DCJ, I actually decided to take the leap, although it was a bit challenging because I'm from Limpopo. And in Limpopo, by that time, we did not have any bar that offered pupillage program. So I had to leave everything and go to Joburg to go do pupillage.
Well, I had to do the same. But you did not stay in Joburg, it seems. You went back to practice in Limpopo.
I was very fortunate, DCJ, in that the year that I was doing my pupillage, it was the year that Senior Counsel Mukari and some other members of the Johannesburg bar and different bars had decided that they would want to form a bar in Limpopo. So that to me came as an advantage to say, now it's time to go and serve your people at home.
Yes.
I then joined the Polokwane bar.
When was that?
It was in 2015. My pupillage was in 2014.
Yes.
Then I was a member of the Polokwane bar in 2015.
All right. And how many were you in this newly formed bar, if I may ask?
We were very few, DCJ. We were actually less than 30, if my memory serves me well. And we were very few women in the group.
Yes, I can imagine. All right, and that's where you have been since?
Yes, that is where I've been since.
You have had an opportunity to act in the High Court.
Oh, before that, DCJ, we have also, from the Polokwane bar, we've now started a new group in Thohoyandou. So I was one of the co-founders of the Thohoyandou group of advocates. Right. So I'm both a member of the Polokwane and the Thohoyandou bar.
Good progression. All right. As I was asking, you started acting in the Limpopo High Court in July 2019.
Yes.
And how long was that stint?
It was from July 2019 up till December 2019.
And you were invited back in 2021?
Yes.
For how long?
I think it was a period of 5 months.
So you've clocked almost a year.
Yes, and I'm also currently, again, I've been called to act in the Thohoyandou High Court. So beginning of this term, I'm seated at the High Court as an acting judge there.
Oh, I see. What kind of work have you done in the High Court during these acting stints?
Within our division, Limpopo division, one is very fortunate because the then judge president could give you an opportunity to be seated in both the opposed roll unopposed civil trials and criminal trials. So I've had an opportunity, and even your appeals and your full bench appeals, and inclusive of reviews. So I've done quite a number of nearly all the matters.
All right. And have you written judgments?
Yes, I've got 25 penned judgments and about 10 extempore judgments.
Okay. In what areas of the law, if I may ask?
I've got 3 written judgments in civil appeals, 3 in civil trials, 9 in opposed motions, 10 in criminal trials. And in the civil appeals, I even had an opportunity to pen a judgment on the full bench, as well as on the criminal appeals.
Okay. Did you inherit any reserved judgments?
No, I do not have, besides a pending matter before me at the Thohoyandou High Court, because the day I resumed duty, I was placed on the criminal roll, and I had about 3 matters, and I had to request from the prosecutor as to which matter had since been long outstanding on the roll. And I noted that it's a matter that had 30 counts, dating back the date of commission. Some of them were committed in 2011. So we then and there on that particular date started with the trial of the matter. And when I postponed the matter on Monday, the state was already leading evidence in respect of count 14.
Okay. Well, I forgot to ask you about one very important aspect of your CV. You're a mom.
Pardon?
You're a mother. You have 3 children,
Yes,
but the youngest is 16, so they're not so young.
yes.
All right. How have you found juggling motherhood with the rigors of practice?
The one that is now the youngest one, I fell pregnant while I was still a prosecutor, and I was a relief prosecutor. So while I was still on maternity leave, the chief prosecutor requested of me to come back, in that there was a certain court that had challenges. And I did not have issues with that because I had somebody to take care of the child. I just took back my work before my maternity leave could even come to an end. So that is not actually one of the challenges that one can say hinders your performance.
Yeah, that's the story of all working mothers
Yes.
across the world. All right, I will stop here, Ms. Madavha, and hand over to the other commissioners to put questions to you.
Thank you,
Starting
DCJ.
with the head of the court to which you have applied. Go right ahead, my sister.
Thank you, DCJ, and good morning, Acting Judge Madavha.
Good morning, AJP.
Am I correct that you are a resident of Thohoyandou?
Yes, I'm actually a resident of Thohoyandou. I reside at a village called Makumeke, which is about 15 kilometers from the High Court.
And that most of your professional life you have been working there at Thohoyandou?
Yes, I've been prosecuting around Thohoyandou, and as a practicing advocate, I'm briefed by local attorneys in Thohoyandou, as well as state attorney in Thohoyandou and Polokwane.
And how often have you appeared in the Thohoyandou High Court?
In a week, I can say I appear about twice in the Thohoyandou High Court
Per week?
per week.
I'm happy that you have realized the backlog that we are having there at Thohoyandou, and that in the recent report we have been reported as one of the underperforming courts.
Yes,
And you are correct that some of the cases started in 2011, 2010, 2017, and they have been on that roll for quite a number of times. There are matters which were postponed 30 times without even a plea. And then what I want to know from you is, how do you intend to deal with the backlog that is there at Thohoyandou, especially in the criminal court?
AJP, I've got vast experience in criminal work, both as a prosecutor and as a practicing advocate. I've noted prior my resumption as an acting judge the fact that the outstanding criminal role is really bad. Hence, the day that I assumed duty, I had to come up with a mechanism to say, out of the matters that appear before me, I need to take preference of the long outstanding matters. Because if you don't do that, with criminal matters, along the road, some of the witnesses lose interest, some of the witnesses might even pass away. Of crucial, some of the accused are in custody. And if such matters are not given preference, and if our role is not performing well, then we are not doing justice to our people. So my take in trying to reduce the role will be, besides the challenge of load shedding that we have, when I resumed duty the first day, starting with the matter that had 30 counts, I even suggested that we should start our courts at 8:30. Unfortunately, when we came, the schedule had changed and electricity could only resume at 11. So I've actually tried and put up skills to say if we are to start our courts a bit early and make sure that we proceed, then that would assist with having our matters finalized. The other thing that I've noted is what could also assist is us having judicial pre-trials with the DPP or the prosecutor's consent. Because at that judicial pre-trial, you are able to check as to what are the challenges. And in me proceeding with the criminal matter, just along proceeding, when witnesses are already done, it's still about 2 o'clock, you are still ready to proceed, then the prosecutor will be telling you, we were only able to secure 3 witnesses for the day. So you are then forced to have the matters postponed. But I'm willing to take up a responsibility with the experience that I possess to clear up the criminal role.
Sometimes we have a challenge with the CCTVs, and we have to move from Thohoyandou High Court to the Sibasa High Court so that we can go and take the evidence of young children there, because their CCTVs is always in order. Are you willing also to move from Thohoyandou to Sibasa or to the nearest court where they have a working CCTV to deal with all those matters that involve children?
AJP, I'm also aware of that challenge that you've just alerted. Let me say from the Thohoyandou High Court to Sibasa Regional Court, it's less than 5 kilometers. Yes. So that to me will not be a challenge, as long as we are able to safeguard the evidence that has been laid to form part of our record as we go along, to try and not lose up the recording.
I never sat with you in the appeal court, but I had the opportunity to see your reviews. You brought some of your reviews judgments to me to co-sign. And I must say that it was seldom that I have to correct. If I have to correct, it will be maybe sentence construction or typo and so forth, but I didn't do much work to restructure your judgment. Now, on coming to civil, I've noted...
Sorry, JP, there's a complaint from this end of the table that they can't hear you.
They can't hear me.
Yeah, just bring the mic closer to you.
Thank you. Now, coming to civil work, how often do you appear in the civil court?
AJP, my briefing work from state attorney varies a lot. I've got a lot of unlawful arrest matters. I've got a lot of medical negligent matters that I deal with. So with your civil trials, I do not have any challenge with conducting such matters.
And I noted that you have attached judgments of dealing with medical negligence to your CV.
Yes.
And I noted that we have many cases that we deal with medical negligence on the roll pending at the Thohoyandou High Court. And some of them have been pending for long. And somehow there is no movement as far as those matters are concerned. I was just trying to find the reason why that is the case, but I've noted that it might be because there are only 3 judges there. 2 are always in the criminal court, and 1 who's doing civil will do everything civil. So there won't be much time to deal with long trials. And we need somebody who can have a strategy on how to go about civil trials, especially medical negligence, which involve children. Do you have a strategy on how we can go about and see to it that these matters are attended to?
IJP, I've realized that as a judge, one would need to sensitize medical negligent matters, especially wherein children are involved. If these matters are prolonged, along the way, you tend to lose these children through death before justice can actually be served on them. So with my experience and the judgment, as well as my exposure in regards to medical negligent matters, I will actually, there's actually a formula that has been introduced by the senior judge in Thohoyandou. He's trying to recall matters that have been stood down or set down until 2025 and even 2024 to bring up the parties to sit down in a judicial pretrial and see what are the issues. Can't we recall these matters and set them down for a nearer date? During the course of the term, when one is done with the term, we've got recess. And once we've noted and marked those sensitive or long outstanding medical negligent or civil trial matters, I'm willing, AJP, to avail myself doing recess and proceed with the matters.
And you realize that you might come and do them pro bono?
Yes, I'm willing, because I've been on the Thohoyandou bench pro bono at some time. I would not have a problem with that.
What is your weakness?
My weakness is I would want to see things being done at a convenient or the soonest time. So if it can be done due to my part, then I feel a bit down. But if it's not due to my part, then you find there's nothing that I can do about it.
Thank you, DCJ. I've got no further questions.
Thank you very much, AJP Semenya. Mr. Singh?
Thank you, DCJ. Good morning, Advocate Madavha.
Morning, Commissioner.
Traditional leadership is an important and strong institution in the Limpopo province. We have almost 200 traditional leaders, including kingships and queenships. Take us through your experience of how many matters you've presided over in traditional leadership and how many judgments you've been, please.
You're quite correct, Commissioner, to say in Limpopo, traditional leadership, it's quite the business of the day. As a practicing advocate, I've got a lot of urgent matters that were urgent, wherein you find traditional leaders themselves are fighting. I've got matters wherein there are reviews brought about by traditional leaders and candidates who feel they are the ones that should have been recognized or appointed. So I have experience in such kind of matters wherein traditional issues are concerned. And in regards, or to be particular to Thohoyandou, I am actually a vendor. So the vendor custom, it's accustomed and well known to me.
Thank you. Have you presided over any traditional leadership matters in your acting stints?
I've presided in about 2 matters. I think one of them was an urgent matter in Polokwane, and the other one was just an opposed motion that involved traditional leaders.
Thank you. My last question to you revolves around the comment made by the Limpopo Society of Advocates at point 15.15, paragraph 15.1.
Fifteen?
Point 1.
Yes.
It reads, our overall view is that the candidate needs to gain more experience before she can be a judge. The bench needs to have judges with all necessary skills. The bench to appoint her will not send a good message to society at large. May we have your comment with regard thereto, please?
I actually checked the comment, Commissioner. However, if we can go back to the very same comments in paragraph 3.2, what they say or submit is to the effect that my appointment at Thohoyandou would actually send a strong message. So their conclusions at the end of the day, take into account the overall rating or comments about me, their decision at the end, I actually am a bit puzzled, because they actually state that punctual in court, my judgments are submitted in time, and that I'm a black female. So their overall comment or the underlying comment to say I'm not a suitable candidate does not actually merit to the contents of their comments.
Thank you, DCJ. That is all from me.
Thank you, Mr. Singh. Mr. Nyambi?
Thank you, DCJ. Morning, Advocate Madavha.
Morning, Commissioner.
If you can share with us your understanding of the doctrine of separation of powers.
The doctrine of separation of powers, actually, it's enshrined in our Constitution to say there are actually 3 arms in government, which is the legislature, which makes the law, the executive, which makes policies, and the judiciary, which tries the matters.
Which one of those is led by 2 people? Arms of the state.
It will just be a guess, Commissioner. I would guess it might be, or let me not even guess. I'm not sure at this stage, Commissioner.
My last question. We know that Limpopo, it's a vast rural province like my province. So something that as you are from that province, it's access to justice. Any particular significant thing that you know that is impediment to the rural masses to have access to justice that you can think of and share with us?
It is indeed true that Limpopo is quite a rural area. And one should state that if the people of the said Limpopo province do not have access to justice, then that will be tantamount to a denial. Access to justice at the end of the day would mean if people are bringing their matters to court, they need to have them speedily resolved.
Thank you, Advocate Madavha. Thank you, DCJ.
Commissioner, APP, is a follow-up? Go ahead.
Would I be correct to say there is no arm of the state that is led by 2 people?
Hence, Commissioner, I actually said I do not even want to guess, because in my mind I was thinking the legislature is not led by two, executive not two, judiciary not by two.
Thank you.
The DCJ, my question was basically along those lines. If you allow me, I can follow up and I forgo my opportunity.
I'm happy with that arrangement.
Yes. Advocate, I see that you have an LLB degree.
Yes, Commissioner.
Now, the lawyers that I meet and talk to, they are furthering their studies, and they say to me they want to widen and broaden their theoretical perspectives on the issues of the law. And there's nothing wrong with that. Why are you not doing the same in terms of advancing your academic career? Is there any specific reason?
Commissioner, besides furthering my studies, maybe in terms of having an LLM, there are courses, short courses that one can take to further their studies, depending on your interests. For instance, for example's sake, if I'm interested, let's say, in corporate law, labor law, or medical negligence, then I can take up short courses. I've actually not considered registering for the master's degree, to be
Okay.
honest.
Now, the theory that Commissioner Nyambi is raising of the separation of power is a long-standing theory of law. They say it originates from a French philosopher, Montesquieu. They call it trias politica. Do you know exactly why it was designed that way? Why there was a need for a separation of powers between the
Commissioner-
arms of state?
Commissioner, I believe that before South Africa was declared to be free and before the Constitution was formed, there wasn't anything like a separation of powers. The Parliament by then could make laws or even enforce. So hence, the separation brings about responsibility. The legislature has got its own responsibility. The executive as well as the judiciary has its own responsibility. So it's about responsibility and accountability at the end of the day.
I don't think that you are answering my question. What you are saying now, it is about the legislative supremacy of Parliament. And in my view, it has got nothing to do with the separation of power between the three arms of Parliament, the three arms of government. My question is, why the need to balance the separation of power between the three arms of government? That's the question. If you want us to talk about this one that we are referring to, what Parliament did before the advent of our new democratic dispensation, we can talk about that. But in this case, I want to understand this long-standing theory that I talk about. Do you know why was the need to have that separation of power?
Commissioner, I'm not sure if maybe I'm not understanding your question, but according to my view, the separation was there in order to have separate arms of the government to take up responsibility for their actions.
Okay, then it's important what other lawyers have told me is important, therefore. DCJ is okay. Thank you very much.
Thank you, DCJ. Good morning, Advocate Madavha.
Good morning, Commissioner.
Just one question from my side. In book 1 of 1, I think it's page 13, you indicate that you have had a few matters wherein constitutional law was an issue as an advocate. That's what you say.
Yes.
Now, one of the cases that you dealt with is the high quality school versus Ministry of Education.
Yes.
Yes. Now, the our constitution makes provision for the sacrosanct or the sanctity of the values like rationality, transparency, and the rule of law. So now what I want to check from you is as to whether rationality, did it play any part in you setting aside the decision by the MEC of Education to withhold the matric results?
When I was vested with the matter, my mind actually went to the provisions of the Constitution that the said learners had the right to education. These were actually matric learners who had written their exams, and when results were released, theirs were withheld. So when I was vested with the matter, I then noted we've got a lot of things at stake. These are learners who are supposed to register at tertiary level. And the reason why the MSc had withheld the matter was due to allegations that the paper had leaked and they were still yet to conduct the disciplinary inquiries. So now the question was, in as much as you still want to conduct inquiries and haven't found the learners guilty, what now about the right of the learners who still need to register a tertiary wherein the said registration time closes? So I would not say I was actually rational about the matter, but just trying to enforce their rights as contained in the Constitution.
But I guess you might have also considered as to whether is there any rational connection between the decision taken by the MEC and the facts at hand, which ultimately influence your decision to set aside the decision by the MEC.
I was actually counsel in the matter. I did not set aside any decision. I was counsel in bringing up the urgent application to have the results released. I was not an acting judge on the matter.
But you agree that the issue of rationality could also be another ground upon which your case was centered around?
I cannot dispute that, Commissioner.
Thank you, Advocate Madavha. Thank you, DCJ.
AP Beze?
Thank you, Deputy Chief Justice. Good day, Advocate Madavha.
Good day, Commissioner.
I've got two questions for you. The first one seeks to test your assertion that you have got vast experience in criminal law. Supposing you sit as a member of an appellate court in an appeal by an accused person against sentence, under what circumstances would interference with the sentence imposed by the trial court be warranted?
Commissioner, in sentences, there are offenses wherein minimum sentences have been provided. So if a matter is brought to me on appeal in regards to sentence, the approach is to check whether the presiding officer or the magistrate that imposed the sentence actually considered the provisions of the Minimum Sentencing Act, whether or not there was a balance between the personal circumstances of the convicted, whether or not the interests of justice, the victim was also considered in the sentence. And if the sentence imposed brings a shock to the community or it does not, then as an appeal court, you check into such kind of irregularities.
Okay. Generally, where the Minimum Sentences Act finds no application. Under what circumstances would interference be warranted?
Generally, under where the minimum sentence does not apply, as an appeal court, you check into whether the sentencing court had actually applied its mind into checking the submitted facts in mitigation as well as those submitted in aggravating, and to check if whether or not the imposed sentence is just under the circumstances.
Thank you. My second and last question. You are presiding in a civil trial concerning a delictual claim where negligence must be established by the plaintiff. Under what circumstances would liability for negligence arise?
The issue in matters where negligence is concerned, one needs to check as to a reasonable man under those circumstances. Could have a reasonable man tried and have done anything to safeguard or to have the negligence not to have occurred? So it's actually to check whether a reasonable man in that position exercised whatever diligence or skills that were in their position.
Just as a follow-up, does the often quoted case of Kruger versus Kutse, a judgment of Holmes J.A. long time ago, reported in 1966 to ring a bell?
Commissioner, at this stage, to be honest, it doesn't actually ring a bell.
Thank you.
Thank you, AP. Deputy Minister?
Thanks, DCJ. Good morning, Acting Judge.
Morning, Commissioner.
Just following on from Commissioner Nyambi's question on the heads of the arms of the state. The President is the head of the executive. The Chief Justice is the head of the judiciary. Who's the head of Parliament?
Commissioner, can I come back to that? Now my mind is a bit blank.
Okay, well, look, in terms of Section 42(1) of the Constitution, Parliament consists of the National Assembly and the National Council of Provinces. So it has two heads, the Speaker of the National Assembly and the Chairperson of the NCOP. I just thought it should be...
Thank you, Commissioner.
I should put you out of your misery on that one.
Thank you so much. Thank you so much, Commissioner.
But my main question is just on the issue of minimum sentences and substantial and compelling reasons to deviate. What would you see as substantial and compelling reasons to deviate? Examples, sorry.
Commissioner, substantial and compelling reasons are not actually described. It actually depends on the person that is before you. Substantial could mean, I once had a matter wherein I think it was a murder trial. I was actually for the accused. And the circumstances surrounding the commission of the offense, that yes, he might have been found guilty of murder, but then somehow the intention was not to commit the said murder. The personal circumstances of a person as well differs. You might find that an accused person, let's say, for example, a 70-year-old has been has been found guilty. Taking into account his age, maybe his medical conditions, the fact that he could have been a first offender, the fact that he does not have any previous convictions, then those can be counted in as exceptional circumstances.
And you are familiar with State versus Machichi, the SCA judgment on minimum sentences, where the court said courts were not free to subvert the will of the legislature by resorting to vague, ill-defined concepts such as relative youthfulness or other equally vague and unfounded hypotheses that appear to fit the particular sentencing officer's notions of fairness. Predictable outcomes, not outcomes based on individual whim, were foundational to the rule of law, and that lay at the heart of the constitutional order. I'm just raising it because there have been some judgments from the Limpopo High Court overturning minimum sentences, which I think should be debated, and it is of concern that minimum sentences are quite strict. That's the intention of the legislature. If somebody commits a rape of a child, unless there are substantial and compelling reasons, they should be sentenced to life imprisonment.
That is true, Commissioner. When the said Minimum Sentence Act was legislated, it was actually for the said purpose, to say as judges or magistrate, you're not to lightly deviate from the prescribed minimum sentences.
Thank you, Acting Judge.
Just before I forget, in response just now to one of the Deputy Minister's questions on what constitutes substantial and compelling circumstances, you made reference to exceptional circumstances, and I want to take that as a slip of the tongue, or did you mean that exceptional circumstances are substantial? Is it the same thing?
Exceptional circumstances.
Are they the same thing as substantial and compelling circumstances?
No, it's not. It was just a slippery of the tongue.
Okay.
Thank you.
Thank you for that clarification.
Thank you, DCJ. Good morning, Ms. Madavha.
Morning, Commissioner.
Yes. I want to propose something to you for your comment, and then I'll explain, I'll tell you why I'm proposing that. I want to propose to you that perhaps your application for judicial appointment comes too early in your professional life, and you should perhaps get more training through acting positions and the SAJE training for aspirant judges. And then I would ask for your comment when I'm done telling you why I say that. I propose that. Looking at your judgments, there are very serious problems of form and substance about the judgments that you've given us. And one has to, because these are the judgments that you have put forward, one has to accept that you consider these to be your best judgments. Otherwise, you wouldn't have put them up. That's the basis on which you put them up. And the issues of form, I won't take you through all of them, but just by way of example, your Molokome judgment, you know the judgment that I'm talking about. This is a father whose wife died in hospital and brings a claim, a dependence claim. You remember that?
Yes.
There are all sorts of errors. It's quite a messy judgment. And I use the word messy not in any disrespectful way, but to make a point that it's not a well-prepared judgment. And it has basic problems such as paragraph numbering. You've not done that. You do that and then you stop somewhere. And then you just carry on writing. There are all sorts of typos and all sorts of things. One would expect, this is a public record, so one expects, if this was not an agent application where you had to do the judgment overnight, one expects that you would have had time to go through it and fix whatever problems there were before you finally signed and put it out there. That's a form issue. But also your reasoning and logic and thought process here. It seems to be jumbled up and all over the place. For example, you it looks like you're analyzing what the witnesses have said, the experts have said, and then you leave things hanging. And I want to take you to, just by way of example, so that you see I'm not being unfair to you with this comment. In that Mulokome judgment, it starts at page 18, handwritten 18, and then stamped 21 at the bottom, 18 is at the top. If you go to that judgment under the heading discussion, and then you talk about what the expert for the plaintiff says, and just by way of example, you say the first difficulty at page 32, bottom 32, you say the first difficulty with Dr. Prominent's evidence is that he concedes that, and then you say something, you carry on. And I looked for what is the second difficulty. It's not there. You just carry on discussing, and I don't know what you've identified as difficulties. But an earlier problem, in fact, also about this judgment is in your opening paragraphs, you say you list common cause facts, and then in the body of the judgment, you repeat something which is not common cause. You say, this is what he says about this issue, and yet the respondent says something different about it, and he didn't know that when he prepared his report. I think that is not acceptable in a judgment that you're putting out there, but also that you're putting up to us for consideration as a candidate. When you finally find against the plaintiff, you dismiss this action, it's not clear what of the plaintiff's expert evidence you have rejected. It's not clear, and the basis on which you did that. So that's one problem, and that's a judgment in 2020, so it's not that long ago. And then I'll skip the next one, which has its own problems, and go to the last one, which is a Baloyi judgment. No relation of mine. And it has the same form issues, but the big one for me, and I don't understand how you got there. This is a claim against the Minister of Health. A special plea is taken that they've got the wrong party before the court. You deal with that, and then you conclude, you issue you say they are correct, the defendant is correct, I uphold the special plea. If you go to the order, right at the end, at page 52 at the top or 55 at the bottom, you say the special plea is upheld with costs. And then you say, and this is a problem for me, you say the plaintiff is ordered to join the member of Executive Council of the Limpopo province as the defendant. Nowhere in the judgment have you said there was an application in the event that I find, I uphold the special plea, that I should hold that the MEC is to be joined. It's nowhere in the body of the judgment, and you dismiss the special plea, which should be the end of the case against the Minister of Health. At least this action that is before you should be the end of it, but you say you're ordering a joinder of the MEC of Health. Where that comes from is not apparent from the judgment. And I can only put all of these and many errors here to training and experience. It's not necessarily an indication, I wouldn't like to think it's an indication of incompetence, but I think training and something that you can benefit from with training and further exposure through acting appointments, and so maybe this application is premature. What is your comment to that?
Commissioner, if I might start with the last judgment that you referred to. It was a matter wherein a special plea was raised to say a wrong defendant had been cited. Now, my take was, at the end of the day, when one has to meet up with justice, this was a claim wherein, if my memory serves me well, it was a claim in regards to a minor child. I just don't have the facts. And in me ordering that the correct defendant be joined in, I did not want to shut the doors against the poor litigant, according to a technicality that could have been caused by the person who drafted the papers. And in regards to the first matter that you referred to, I should be honest to say that the matter was a bit complex. You would note that it was a medical negligence matter. I had to take my time to research, familiarize myself with the medical terms after having had evidence, and to consider the expert evidence, the expert opinion that was brought before me. With the issue of numbering, I just want to believe that that could have been an error on my part or on the secretary that assisted me in typing out the judgment, that I should have checked and made sure that the numbering is correct.
Yes.
But I would want to say that I am ready for this position, and with the mistakes that you've shown me, and with the practice and experience that I've now obtained ever since this judgment was written, I believe this is a mistake that I haven't done up to so far. And I would assure the commissioners that I've gained the relevant and enough experience, because these are judgments that I penned down during my first acting stints.
Yes. Can I just and this is just a last observation. On that last judgment where you say you think in your recollection it had to do with a child's claim, none of that is in this judgment. There's absolutely no explanation, even if you could do what you've done, which is to order that the MEC should be joined, even if you could, which I don't think you could. Even if you could, nothing in this judgment explains why you conclude that way with that kind of order B. It says nothing about what this claim is about. You say there's a claim against a minister, a special plea was taken, and this is the special plea, and I uphold the special plea, and I order the MEC should be joined. That's all that this is, and I'm uncomfortable that you are not accepting the fundamental flaws in these judgments. You're not accepting that. And in my opinion, that closes the door to growth and development and further training if you do not accept. And you make an excuse about the first judgment. You say it's my PA. No, it's not. It's your judgment. It's your judgment. You signed it. It's completely unacceptable that you would say it's my PA. It is your judgment. Thank you. Thank you, DCJ.
Commissioner, I own up. I accept my mistake. It's not like I'm trying to shift the blame.
Thank you. Thank you, DCJ.
Follow up.
Thank you, DCJ. Advocate Madavha, it's just a follow-up to the question posed to you by Commissioner Baloyi. Reading your judgment, do you accept that the MEC for Health was not before you? He was not given an opportunity to present his or her case, and now he is faced with this fait accompli that he is a party to these proceedings?
Commissioner, the special pleas that were before me were that of non-joinder. The defendant was saying the MEC of Health should have been joined and misjoinder. Hence, I ordered that the MEC of Health be joined due to the fact that the special plea was that there's this non-joinder of the MEC of Health.
But the essence of my question is that the MEC for Health was not afforded the opportunity to speak for himself or herself on that issue.
That is so. That is so, Commissioner.
Thank you. Thank you, DCJ.
No, just a quick follow-up. Commissioner Baloyi says you were these judgments that you have put here, they were not put by anyone else but yourself. And you regarded these judgments in a way as your best judgments that you can put forward. Then when mistakes are shown in those judgments, you say, no, those are old judgments. I've since improved. Why didn't you bring the improved judgments instead of bringing the mess that has been presented before you? Because if you say those are old judgments, meaning there are new judgments which have extremely improved and you have not brought them to our attention, how do we confirm that indeed you have improved from all those mistakes which were pointed at you?
Commissioner, if you can have a look at the judgments that I attached, I tried to spot out different kinds of matters. The one that Commissioner Nyambi pointed out is that of medical negligence, which was a civil trial, and I've also attached a criminal trial judgment, and I've attached an opposed. So I was trying to show to the Commission the different kind of judgments that I've written, regardless of maybe the flaws of that have been shown to me, which I acknowledge. However, I can state with certainty that I've actually improved, and my reason of attaching these judgments was to reflect on the different kind of judgments that I've written.
Follow up,
Thanks,
CJ.
Commissioner-
Follow up, CJ.
Yeah, before that, JP Mlambo.
Thank you very much, DCJ. Good morning, Advocate Madavha.
Morning, JP.
It's a follow-up question, and I'm here representing heads of courts. And one of the objectives of me being here is to also see that people who are interviewed and who are recommended are actually ready for permanent appointment. So my follow-up is, have you ever attended a judgment writing judges training course?
JP, I was, after this, the judgment that I attached, I attended the advanced training. You were one of the facilitators in January 2020 or 2021. The advanced training course for aspirant judges.
Yeah, I'm talking
Yes.
about, there was a course on judgment writing there.
Yes, I've attended to that one.
Now, you acted after that training course, didn't you?
After that training course, I acted pro bono in Thohoyandou and only came back now in 2023.
Is there no judgment that you could have attached that could have shown us that the advanced, and you were lucky you went into the advanced one, judgment training course you attended helped your judgment writing?
After that training, JP, I do not have any judgments that I compiled in Thohoyandou because I was actually on pro bono and assisting when challenges or when there was a shortage of judges in Thohoyandou, and I was actually placed in the unopposed role.
I see. Thank you, DCJ.
Thank you, JP. Prof. Marumo,
Thank you very much, DCJ. Mine is also a concern in relation to the structure of your, and I accept that there are most of the judges, including those perhaps in the Supreme Court of Appeal, when they structure their judges, just before their first paragraph, mostly they don't put anything there, and some will put background or factual, something like that. But what concerns me is, in your judgment, you have these three headings. You have the law on the one, you have legal framework on the other, and you have the legal test on the other one. But it seems to me that after that particular subheading, there is nothing that follows in terms of dividing what you are doing. After that subheading, you go on and on up to the time when you are giving the order. So it appears as if the order is inclusive to the law that you have just provided. And it is difficult to realize as to when does the discussion of the law or the statement of the law starts and the discussion of the law commences and the marrying between the facts and the law actually is done. I thought it was something that is quite disturbing about how you structure your judgments. Any comments?
Commissioner, I believe I've made my submission in respect of that judgment, and I wouldn't like to take it any further.
Accept that, it's fine.
Okay.
Thank you. There was a hand up in the virtual platform. Do you still want to ask the question, Commissioner, whoever you are out there?
Yes, Chief Justice, if I may.
Yes, go ahead, Mr. Bernard.
Advocate Madavha, the various law bodies, the LSSA, the Limpopo Society of Advocates, and even to an extent, probably Nadel, but there is an indication that Nadel refers to a certain evaluation of expert evidence and test of negligence on that seems shaky, but the other society and the Law Society and the Limpopo Society of Advocates indicate that they seem to feel you need more time. And I mean, these are colleagues that appear in the court, that have experience of the court and so on. What would you say to allay their fears, to convince or persuade the JSC to still, despite those comments, go ahead with an appointment?
Commissioner, with Nadel comment, I should state that on paragraph 4 of their comment, that is now found on page 54, where they say a reasoning in the Mukute matter against the MEC for Health regarding negligence, the test, and they go on. I should state that this is not my judgment. I tried to check in all the judgments that I've penned, and I couldn't find. It's unfortunate they did not even include the case number, which could have made it easier for me to locate the said judgment. But with all the judgments that I've penned, this is not one of my own. However, to try and convince the commissioners that I'm ready, I will try and Commissioner Baloyi to say your mandate in requesting us to celebrate 100 and more, that campaign. I was fortunately tasked by our AJP to be one of the facilitators in Thohoyandou High Court. We have done that. We celebrated that this Monday, and our main focus was to say we should invite learners from the local university who are women to try and alert them about the regulation that was passed on the 10th of April 1923, which allowed women to be admitted to practice as attorneys and advocates. So that was done, and it went very well. It was informative in that our main objective was to say, yes, this is 100 years and more after this regulation was signed. But as women, where are we? Are we really winning in this profession? So we had different stakeholders who came and addressed the women. And I'd also want to submit that one who is for transformation. Within our bar, the Polokwane bar, I've been tasked with different peoples over several years. When the bar started, it was only a few chambers that were available, but we had taken up a lot of peoples. I opened up my chamber for any people who wanted to use my chamber. I remember opening it up for two people whom I gave my keys and let them use my chamber. Besides that, I was even given a people who was not from our province. The said people struggled financially. I had to come to his rescue and assist him throughout the whole pupillage program. I was also one of the members who seated in the interviewing committee to interview pupils for pupillage program. I even went further in assisting in lecturing them. So I'm here to say with pride that with transformation, I'm putting my hands to assist with peoples around our province. And besides assisting the peoples only, to also assist our junior peoples, because the practicing advocates who are here are quite aware of the challenges that we face as junior advocates to get briefs when one is done with pupillage.
Thank you, Advocate. Thank you, DCJ. I think I'll leave it at that. Thank you very much.
Thank you, Commissioner. Any further questions, colleagues? Ms. Madavha, it looks like we've come to the end of your interview, but before I let you go, I just want to send you off with this message. There is indeed an urgent need to advance women, not just in the judiciary, but everywhere they find themselves in the workplace. But women are not given a seat at the table simply because they are women. They must prove that they are able and competent to do the job at hand. Now, you have pinpointed Commissioner Baloyi, who was suggesting to you that you may benefit perhaps from further training, training because, you've had training, further training, yes, and maybe more acting stints, and it does not appear that you agree with her. And I don't know, the Commissioner will still deliberate and decide what to do with your interview. I don't know what the result will be, but I just want to implore you to take that advice. It is sound advice, please take it to heart. Thank you so much for making time to attend the interview. You're excused.
Thank you so much, AJ.